I'm Laura Crawford. I'm representing the appellant Damian Norby. He's the father of the children Justin N. and Darian
Would
N.
counsel pull the microphone down a little bit?
All right.
Yeah.
You know,
Thank you.
this is my second appearance before this court, and the first time was virtually, and I had audio issues then, so my apologies.
Glad you're here.
But anyway, this is a termination of parental rights matter.
You want to reserve any time for rebuttal?
No, Your Honor.
Okay.
Excuse me. Excuse me. Just a little factual background, or at least procedural background. The children were moved from the custody of the appellant and the mother, Robin Pierce, by DCS on about September 10th of 2020. There was allegations of illegal drug use by the mother, and then some concerns with regards to the appellant's mental health. And on the 20th of 2022 of September, the Polk County Juvenile Court had found the children dependent and neglected and had placed them in the custody of the appellees. And the appellees were the paternal grandfather and step-grandmother of the children. There was an adjudicatory order that provided for certain requirements for the parents to complete before they could petition for a return of custody or get any unsupervised contact. And it's pretty much mirroring about what your general standards of a DCS safety plan or a order for return, basically obtain mental health assessment, A&D assessment, drugs and so forth, counseling. The father, he had substantially completed the requirements, and he had filed a pro se petition on or about March of 2021. And there was a hearing on the petition that was scheduled on August the 10th of 2021. Unfortunately, father had missed that court date. He appeared one day too late, but upon discovering his error, he immediately had filed a petition that following day. And I believe it was stipulated on the record that the appellees had been served with that petition. And then at that point, the appellees had filed their petition on September 20th, which stayed any action in the juvenile court. And then we heard our matter on the termination. Of course, I've brought, as you saw in my brief, that the three issues was just basically we didn't feel that there was a clear and convincing evidence presented that the father actually abandoned the children for failure to provide financial support or failure to visit the children by statute. And then also we believe that the court erred in finding grounds to terminate father's parental rights under TCA 36-1, 113G14, finding that the father was not in a position to take custody of the children. And then even if grounds, you know, if the court even agrees on the grounds, we still feel that there wasn't enough evidence to find that the termination of parental rights was in the best interest, at least as to the father. It was definitely, as far as our look back with regards to the issue of the abandonment, it's undisputed that the applicable look back period was May 20th of 2021 through September of 2021. And just keeping that in mind, I'm just going to point to the visitation and the child support on the abandonment. First off, on the visitation, and there's sort of some conflicting testimony. I think the court, between all the testimony, between about 9 to 11 in-person visits were made by the father at the appellee's home in Clarksville, Tennessee. At that time, prior to around the time...
How many visits during the relevant time period by statute?
That would have been, the last was March of 2021, so during the statute, the in-person visits was not during the look back, but there was telephone and video chats. And I want to, and then again, I'll address too that with the analysis that there were telephone calls and video chats during the applicable look back period. The last visit was around the time that father had filed his pro se petition, and that's when things sort of got sporadic. At the time of placement, father and the appellees, particularly his father, the paternal grandfather that's the custodian, they were estranged. And even through all of this, they had a very strained relationship. And I've made, you know, a big point, especially in my brief, that there was lots of acrimony between the father and the Pelleys, and like I say, more particularly the father and the paternal grandfather. Telephone calls and video calls were cut short. Of course, they made the arguments that father had, violated their ground rules that they had.
Counsel, excuse me for interrupting.
Sure.
Did the trial court make any credibility determinations?
They did. They did. As far as with the in-person visits, I think the trial court had found that they were finding there was 9 as to the calculation of the appellees, whereas mine was 11. The credibility issue certainly was to the child support issue, which was what I'd get to, in just a second. But as far as the visits go, the court just pretty much went with the number of 9 in-person visits versus our argument of the 11.
Did the trial court articulate specific credibility determinations with reference to parties or witnesses?
I'll be honest with you, I don't think as to the visitation, but certainly to the child support issue. In that, the recollection, I really don't have the recollection as to the particular, but definitely on the child support. It was actually the number of visits, I think, was what the issue that, with the credibility there. But I wanted to point too that...
Let me, before you leave that, let me ask you
Sure.
a question, please. So, how was the visitation structured here? We're talking about, you had different kinds of visitation. You had telephone visitation, you had video visitation, you had in-person visitation. What did the court allow, or did the court address those issues or leave it up to the parties? Or?
I believe I did not represent the appellant in the juvenile court, and this is something that I have an issue with quite frequently in these type, especially with the family placement. It was left up to the parties, and especially when you have estranged, it's a recipe for disaster. And two,
Sorry for interrupting, but so the
Yeah.
court just said, you've got visitation.
there was no structured visitation. There was no order of child support, which, there was, no, it was just basic. And in light of two, and this is where things get a little more difficult, is the appellees live in Clarksville, Tennessee. My client at the time was living in Benton. He has since moved to Knoxville during the proceedings, during the termination, but at the time it was filed, he was still living in Polk County. And so you had like a 3-hour drive one way. Now, they made the argument in both their brief and in trial court that they had never refused him, that I think in the brief it was said that there was unfettered access. Well, when somebody's, having to get appointed counsel, their resources financially are limited, especially with a 3-hour one-way trip. So he made what visits, he could prior, to his filing the pro se petition.
Let me delve just a little deeper
Sure.
here. What does the law say about telephone visitation and video visitation at this point in time?
I haven't seen, or I didn't find any, I think pretty much what someone, what a party can do given their resources and what they can, as long as we can try to have a meaningful visitation and contact, I think that's, what we need to look at. And especially in light with acrimony and so forth, I had used, of course, the In Re AMH, where the Supreme Court concluded that it was inconsistent that a parent could be willfully failed to visit if there's, acrimony, and especially if they redirect their efforts in going to the courts. And I keep hammering to the fact, especially in my brief, that keep in mind, approximately 6 months after the children were removed, there was a pro se, and during the majority of the time frame of the look-back period, there was a pro se return of custody petition pending. And then, like I say, unfortunately, he inadvertently, got his court date wrong, but immediately filed another to try to, get that case back on. And unfortunately, he was pro se, and just like in the previous case there, I didn't have the luxury of representing him in the juvenile court to be of any assistance to help And I don't know if that would have made any difference or not, but there again, when pro se folks, they don't know exactly what their rights are. They just know they're just trying to do what they need to. But anyway, I was too with there is the undisputed fact, I'll have to concede there, that the father did not pay child support. There again, the court did find credibility. My client had testified that he had offered to pay and it was refused. That I think
And the petitioners testified to the contrary.
Exactly, and the court did find credibility.
As to he believed the petitioners.
They did, but I still look to, and again, I'm going to hound on that, and I think going with the In re Evangeline S analysis that kind of went using the same analysis with the AMH, that if the trial court could infer that father's actions when he went to petition the court, that he was not willfully trying to get out of financially supporting his children. He was actively seeking to get the return of custody of his children. And, so I wanted to try to use, of course, that's the analysis I have to go with in light of what we're doing. And the court also found, as far as there's the two-prong test of the grounds under 36(1)(113)(G)(14) must be proven by clear and convincing evidence that father failed to manifest an ability and willingness to personally assume legal and physical custody and assume financial responsibility for the children. And as I had cited in re Serena W., the parents demonstrate a willingness by attempting to overcome the obstacles that prevent them from assuming custody or financial responsibility. And the parent must demonstrate ability and willing as of the date of the termination. At the date of the termination, the father had completed the A&D assessment that was required by the juvenile court. He attended outpatient therapy sessions. He had submitted a clean hair follicle. There was online anger management that he completed. At the time of the filing, he was employed with a Blaylock Construction and was living in Polk County. He has since moved to Knoxville. The court did bring up the fact that he did not have a valid driver's license, which he had admitted to, but there was no proof to the contrary. It showed that the lack of that driver's license, that he had been without any employment or that hampered his employment or so forth. And then two, another thing, the father was actually in the midst of the proceedings. He was granted temporary custody of his children's half-siblings. They were also removed from the home and were put, I'm not sure where they were placed initially, but apparently the trial, I don't know if he had filed some petition or what, but the court, the juvenile court had granted him custody. Now, the trial court made note in its findings that this was upon DCS's objections for various reasons. But I think it should be noted that the recommendation of the guardian ad litem in that order and the findings in the juvenile court was that placement was in the best interest. So I would think it would be a fair presumption that we could make that the juvenile court found the father had the ability and willingness to assume legal and physical custody of those half-siblings. If that's the case, then surely he would have the ability and willingness to assume the legal and physical custody of his own children.
Doesn't, or rather, how does the finding of failure to pay child support work with willingness and ability?
Well, there again, I have to just resort back to the best argument I can make under the analysis that he had filed that pro se petition in trying to get a return of custody during these proceedings.
Let me ask you rather a more pointed question, I suppose.
Sure.
Unless this court were to reverse the finding of failure to pay child support, doesn't that also take care of the willingness and ability argument as well?
Can you repeat that? I apologize. Can you repeat that?
No, I'm just asking you, if it seems like that would be the analysis, that willingness and ability, one of the mainstays of willingness and ability is either I've supported my children, or there's some reason I haven't. And unless there's
It's a
been a
fair-
finding that he didn't, and unless we
Yes.
reverse that, doesn't that take away one of the mainstays of willingness and ability?
That's a fair argument. I mean, it is. The main thing, and the biggest thing is the best interest is to, like I said, I understand there's a weak, I'll be candid with the court. The child support is definitely the weakest argument. I mean, there's no doubt about it. You just do the best that you can with what you got. But I will say, as far as the best interest, anyway. Thank you.
You can finish your sentence.
I was just going to say, when the court looks at the record as a whole and looks at actually the best interest, I think they can find that even despite as far as the grounds, there was a meaningful relationship that the father had, and that actually there was that the court did not find, and there wasn't enough evidence presented that would actually be in the best interest of these children that they sever their relationship with their father. Thank you.
Thank you. Hear from the appellee.
Good morning, Your Honors. Phil Jacobs from the Bradley County Bar for the appellees, David and Lisa Norby, the petitioners in this case, and the paternal grandparents. To answer a couple of the direct questions that were asked, the finding by the trial court was that there were as many as 2 visits during the look-back period, but more likely only 1. And that was a discrepancy between the testimony found in favor of the petitioners. And then the credibility issue was...
Were those in-person visits?
Those were in-person visits.
Okay.
And to answer your question, I'm not sure about the law in terms of a case on point, but I'm confident that this panel and every other panel in the state of Tennessee would measure regular phone contact and virtual contact at some level equal to in-person visitations. I can't see that would seem very inconsistent if you're talking about building a relationship and what type of relationship that a parent would have with a child. It would be inconsistent to say that you're going to discount telephonic visitations, and particularly FaceTime or some type of virtual visitation, if that answers your Honor's question.
I suggest you might be surprised at what the law says about telephone visitation.
Well, I agree, because what I've read about it, I think is in line with that, but I think that's very inconsistent, and as a practitioner, I think that law needs to be addressed. But it certainly is going to turn on how good the telephonic contact is and how good the virtual contact is. I mean, cases that we're trying every day, people are spending hours on the phone with grandchildren or children, whatever the case may be, in terms of trying to keep a relationship viable. Be that as it may, to answer Judge Frierson's question about credibility and then about visitation, in the findings, Judge Sharp stated this: the court finds that both David and Lisa Norby testified that they never denied Damian Norby any requested visits with the children. Only the visits take place at an appropriate time and under appropriate circumstances where they could be present to monitor Damian Norby's visits. The court agrees that this was very appropriate under the circumstances. Furthermore, this court finds the testimony of David and Lisa Norby to be extremely credible, and that is their opinion that Damian Norby still suffers from extreme anger issues. So coming out of the juvenile court, the finding of dependency and neglect, it was visitations should be by agreement. And my clients, as the finding is here, made it possible and made it reasonable under the circumstances for Mr. Norby, who's one of my clients' children, to come to Clarksville and to visit and to make themselves, or really the children, available for visits to the extent that they could. I want to start with this, and I want to address those particular questions, but it's abuse of discretion challenge here, and there's no doubt the trial court applied the correct statute, the correct burdens, analyzed the best interest appropriately, and made all the findings. There's 3 grounds: by clear and convincing evidence, and then best interest by clear and convincing evidence. The trial court went above and beyond to appoint not only Ms. Crawford, who is an excellent practitioner, skilled and experienced in this case, to an indigent defendant, and Mr. Marble, who is a caring and skilled guardian ad litem. Also, Ms. West was appointed to represent the mother, and she is one of the foremost experts in our district in defending these types of cases in this type of litigation. So with all the proper representations before the court and a entire day trial and a 22-page opinion, the court found 3 grounds and best interest. The court emphasized in this opinion a 2-year period. The court started really in August and then in September of 2020, because that's when the DCS intervened and removed the children who were living with both the mother and the father. And really there was a third party, the maternal grandmother in that situation, who had significant drug issues with prescription medication, methamphetamines, suicide attempts. The mother had gone missing, and the father was strange fact pattern out looking for the children when the law enforcement intervened, and then DCS did the removal. There was an entire trial, and dependency neglect was found by clear and convincing evidence at an adjudicatory hearing. Then a whole year went by, which the court particularly emphasized, where, again, father tried to rehabilitate himself. Mother made no attempts to rehabilitate herself. The father filed this pro se petition and then did not show up to court. I was in court with my clients at that time, representing them in defending the custody litigation. When he did not show up, he alleges that he did refile. I think he did refile the next day or so, and then this action was brought within several weeks after that to terminate his rights.
Counsel, what was the trial court's finding as to risks of substantial harm?
Risk of substantial harm.
Under willingness and ability.
Well, I don't think that the trial court used substantial risk of harm, but the child court.
Risk of substantial harm, not substantial risk.
Sorry,
of harm.
risk.
Yeah, that's okay.
I don't.
We mess it up too.
I've read this opinion several times, and I don't think that verbiage was used by the trial court, but there was a particular emphasis on emotional harm, physical harm, and psychological harm. When the children were removed by the Department of Children's Services, the testimony is clear that the children were suffering nightmares, night terrors, significant bedwetting, anxiety, and nervousness. And eventually, when the children were placed into counseling by my clients in Clarksville, they were diagnosed with post-traumatic stress disorder. So significant emphasis was placed on the trial court with reference to Your Honor's inquiry. The look-back period, particularly with grounds, is there was no child support paid for the year before the filing of this petition while the children were in my client's custody, none after, so the case went on for about 9 months, so no attempts to pay child support after.
But what did the trial court find about the offer? The appellant says he offered to pay child support, and as I understand it, perhaps it's just semantics, but he would bring it next time or something like that. And what was the specific testimony, and what was the finding of the trial court about that?
The trial court, my recollection is the trial court found in favor of my clients in terms of credibility that he had never made that offer,
That the offer had never been made.
I don't think that the offer had never been made, that he never fulfilled that offer there was no refusal to accept support, is the way that I understand the testimony, that he may have said what Your Honor just
Well, that's what I'm trying to ascertain, is whether he ever offered or whether he failed to deliver on that offer.
I think it was that he failed to deliver on that offer. There was significant testimony about my client and clients paying money to the father in the months leading up to the removal by the Department of Children's Services in order for him to keep his lights on and keep his rent paid, et cetera, so that he would not lose custody, and that those loans were never repaid. So whether he offered or did not offer, he certainly never fulfilled not only his obligation to pay support as a parent, but did not repay those loans that were made so he could try to keep custody of the children. This is a unique case as it goes because the father testified that he made $20,000 to $30,000 a year, that he made $20 an hour, that he had worked during the entire life of the children, that he had the ability to work, even though he didn't have a driver's license. His then girlfriend, now girlfriend, was driving him to and from work so he could make money, and there's no argument that he did not have the ability to pay. As Ms. Crawford alluded to, he petitioned the juvenile court and took on custody of 2 other children over the objection of the Department of Children's Services during the look-back period. He was living with his girlfriend, not his wife, but his girlfriend and her 3 children, so there's a presumption that he was supporting those 3 children. So one of the 2 children that he got custody of, he sent to Knoxville, to, I think, Missouri or somewhere out west to be with another relative because he couldn't handle that child, and that comes into the psychological part, which I'll address in just a second. The court found that he never bought any clothes, never paid any medical bills, never sent any cards or gifts, no letters, no expense of any kind was paid on behalf of these children. And certainly the burden shifts to the father after there has been a finding that he did not pay during the look-back period of time. So the father bared the burden the entire time, whether it's that he made offers and didn't fulfill offers to pay or that he never paid. The burden shifts to him with that clear and convincing evidence finding. With reference to visitation, as we've already alluded to today, those credibility findings were resolved in favor of my clients, and that I think the court was generous, or at least tried to be lenient in that finding that he visited up to 9 times, and what I counted was 19 months between September of 2020 and March of 2021, and then 1 or 2 times during the applicable look-back period of time. Particular emphasis was placed in this case on the post-traumatic stress disorder and that finding by the counselor, and that the children would regress during phone conversations or during visits with the father, particularly when the father had brought up that he had gotten custody of these other children and then those children had been sent to live somewhere else, that the children had a significant adverse reaction to that. Before I address best interest, there was the G14 finding where the father was living with another woman. He was still married and made no effort to get divorced. He had no driver's license. He was living in a 2-bedroom home with the girlfriend's 3 children and these 2 other children and 1 other child, depending on the time frame, and that he was just not in a position to care for these children or to address the significant emotional, psychological damage that they had endured, and that it would be harmful for the children to be returned to the father, and we should not negate this. The court, though, allowing Ms. West to withdraw at the trial date, equally addressed the mother in these findings to ensure that all the grounds for abandonment, for failure to visit, failure to pay, and the G14 ground were all found against the mother, and the court carefully analyzed the best interest against the mother, terminating her rights as well. We're focused on the father here today because that's the challenge. With reference to the best interest, the court analyzed this under the old factors, which were not enumerated now, I think A through O or whatever it is, but just I think the 8 or 9 factors that used to be in the statute before it was amended. And the court obviously does not looked at every factor, but particularly emphasized that it would not be safe physically, mentally, emotionally to return the children to the father or the mother, and that the parents in this case had not made a lasting adjustment so that children could be returned to them, particularly emphasizing it had been 2 full years, and the court, after hearing the testimony of the father, did not believe that it would be safe or appropriate, certainly not in the children's best interest, to return them to the father in the circumstances as it was presented on July 11th, 2022. Certainly, the court emphasized that there had been no regular visitation, which is one of the grounds in the old statute and in the new statute, and no support paid. So the court found those in favor of the petitioners in terms of analyzing best interest. And again, to Your Honor's point about harm to these children and what it would look like, the counselor testified virtually, but testified in this case, and the court put a significant amount of weight on that professional's opinion about where the children had come from in terms of the night terrors, the bedwetting, the trauma that resulted in the post-traumatic stress disorder, to where the children were now, which was thriving in school, thriving in the home of the petitioners, and in all ways socially and otherwise rehabilitated from the significant anxiety and nervousness that they had demonstrated in leaving the father and mother's custody and being placed with the paternal grandparents in Clarksville. And so we would ask the court to find that the father has not met his burden, and this court should not overturn the court's findings of 3 separate and distinct grounds for termination by clear and convincing evidence, and that this court should not reverse because appropriate findings were made with reference to best interest, and it being in the best interest to terminate the father and the mother's rights. And the guardian ad litem, as it is here, I think, supported the trial court, and the trial court weighed that into consideration. At least that's my recollection. Certainly the guardian ad litem's not here today. Any questions?
No questions. Of course, thanks to counsel for both sides. We appreciate your arguments this morning and your briefs.